Hi, everyone. Thank you for joining in for today's roundtable on data privacy, the road ahead. I'm Prateek Bakshi, and I'll be moderating today's session. Before we get started, just a couple of housekeeping items. The event is being recorded, and we'll share the recording with you during the course of this week. And in the next hour or so of this roundtable, we want it to be as interactive as possible. So please feel free to shoot as many questions as you have. And some of you have already shared certain questions with us while in the registration forms. The speakers will try addressing these, as many of these as possible during the presentations. And if not, it'll be presented after in the Q&A session after the presentations. And just in case there's certain questions which have been left unaddressed, we'll endeavor to get back to you by email with the answers in the due course. Now, let me quickly help recap, where we are in terms of data privacy and what has happened in relation to data privacy in the last few months. So, India's data privacy law has been on the brink of an overhaul since the Indian Supreme Court's 2017 ruling that held that information privacy is a fundamental right. Now, as on date, India does not have a data privacy regulator, and its privacy laws are contained in 2 pages of rules adopted back in 2011. The first iteration of the proposed law was released in 2018. Subsequently, the second iteration, the Personal Data Protection Bill 2019, was referred to a joint parliamentary committee for its review. Both these drafts were based on GDPR and were slated by industry and civil society alike for introducing complex and arguably unworkable concepts in the Indian compliance framework. The JPC in its report proposed 91 revisions to the 2019 bill, including a suggestion to include non-personal data within its ambit, following which the 2019 bill was withdrawn earlier this year. The sense at that time was that the government is making a clean slate to put forward a much different bill, and that is what happened about a month ago. We have a few more days until the draft is out for comments, and the expectation is that a very similar looking draft will be formally approved by the Parliament in early 2023. Now, before we start with the session and the Q&As, let me briefly introduce all our speakers here today who have kindly agreed to join us. First, we have Bibhav Pradhan, who's a senior legal counsel at Unilever India, where he has been working for over 11 years. He is part of the company's beauty and personal care business and also serves as the data privacy advisor for the South Asia cluster. So welcome, Bibhav. Up next, we have Georgina Graham, who is an associate director with Osborne Clarke. Georgina advises clients on a full range of data-related issues with a particular focus on data protection and privacy compliance. Thank you for joining in, George. And finally, we have Vikram Jeet Singh, who is a partner at BTG Legal, where he heads the technology, media, and communications practice. Vikram is a sector specialist in laws relating to internet regulation, digital payments, fintech, e-commerce, online content. He regularly advises clients based out of the US, Europe, and Asia on Indian IT laws, particularly in context of data privacy, online content, and online advertising regulations. Thanks for joining in, Vikram. Now, to begin with, let me first bring Vikram onto this. Vikram, you're a practicing lawyer in India and you advise Indian and overseas companies on data privacy compliance. Can you give us the basics of this new proposed law? So, for instance, what does this bill regulate and what stage is it at and when will it come into force, etc.?
Thanks, Prateek, and hello to everyone. Thank you for joining us. It's great to be a part of this esteemed panel, and I'm looking forward to the discussion. Setting the scene very briefly, then, Prateek. Like you said, India's current data privacy regime dates back more than a decade. Since then, the economy has moved on quite a bit. At the same time, there have been other Indian regulators who have touched upon data privacy. I think we will all remember the RBI's 2018 direction that payment data should be kept in India. And non-compliance with this actually led to a few card networks being banned from issuing new cards. So it's not that data privacy is a new field, but it's essentially a field which lacks a governing law which encompasses everything. So The new law is the latest iteration in the process, like you said, which started a while ago. This regulates personal data, which is data that can ID an individual. If your business collects personal data, you're a data fiduciary. Even if you don't collect personal data directly, but you end up processing it in any manner, you are regulated. Processing has been defined broadly as well. It includes any operation made on digital personal data, including recording, collection, structuring, storage, sharing, disclosure, or even erasure. So the 2022 bill essentially applies to data fiduciaries and data processors who touch the data of data principals. Data principals are primarily Indians, as that's the remit of the bill. But I think there are a couple of caveats here that um, the bill doesn't refer to the nationality of the individuals or data subjects as such, but essentially, if you are collecting data in India or if you're collecting data of Indians from abroad, but in connection with the business activity in India, then you're probably regulated like this. Now, as a data fiduciary, or what we call as a data collector, this is the equivalent of the data principal. Of the data controller in the GDPR. As a fiduciary, your obligations are to give prior notice to the data principal, to take to consent from them, and to maintain security. And there are certain special protections for children's data. In addition, the government will at some point notify a special class of data fiduciaries called significant data fiduciaries who will have certain other obligations, including having data audits conducted. If you remember Prateek, last year when the IT rules came in, the safe harbor intermediary rules, they also had a sort of a parallel, topic category in something called significant social media intermediary, which for intermediaries who had more than 5 million users. So this is sort of a similar formulation that certain fiduciaries will be designated as significant, and they are the ones who will have the most strenuous obligations. Now, in terms of what the bill, where the bill is at right now, the bill is out for public comments. This is the actually the last week in which you can give public comments to the bill. Uh, from what we hear from industry sources, this actually is a bill that the government is quite keen to pass. They think this is pretty much almost in its final form already. This is about 80 to 90% of the bill that will actually pass, and this will be taken up in the Parliament's budget session, which is coming up in maybe early 23. And given the parliamentary math, this will be passed quite quickly. After it's passed, hopefully there will be a grace period or a bedding in period given, and the provisions of the bill will be made enforceable in a time bound manner. So that's Pratik, initial snapshot laying of the land about the data privacy bill.
Thanks, Vikram. Just one lead question on that as to what do you think is the thinking behind this bill? The government tried a GDPR kind of approach to privacy regulation, which did not work. And what does this bill, why does this bill look the way it does now? Like, what's your opinion on this?
Yeah, it's a much simpler bill, Pratik. I mean, earlier, we were talking about data privacy drafts that were 80, 90 pages long, and had, 70 to 90 sections. This is a 30 section bill, it's actually a fairly compact bill. I think, and that's an intentional change in the government's tack. So the government tried essentially, adapting GDPR to India, and they weren't successful, to put it very bluntly and maybe slightly impolitely. The last bill, was heavily influenced by GDPR, and it sought to, include standards, like privacy by design, which are fairly, alien to Indian jurisprudence when it comes to data privacy. But the new bill seems to have learned from its predecessors. It does away with a number of, concepts that are GDPR specific, that may or may not have been workable in India, and it's actually a lot more leaner. It's a lot more focused on data subject rights, on the protections that have to be afforded to them by data fiduciaries. It also actually does a little bit of a trick in which it leaves a lot of stuff to be decided later. So there will be a data protection board which will be constituted. India does not currently have a data regulator. I think this is a big step because following this bill, India will have a data protection regulator. This regulator will come up with a lot of standards and practices including, for instance, standards around collecting children's data, or maybe even practices around data transfer. So a number of these items will be decided in the future when the data protection board comes into being. But one thing that struck me, and I'll close with this, is that the emphasis on this in this bill seems to be on simple language, clear language, and this is actually a phrase which is repeated often enough in this draft bill, in the explanatory note that the government issued with the bill. And this is a law which has actually illustrations, and which are not common under Indian laws. I mean Indian lawyers will remember that the Indian Contract Act, which was written about 150 years ago, that has actually very helpful in illustrations, and that's a good law. And this data privacy bill actually also has a fair number of helpful illustrations. So I think there has been an effort to make this as much user friendly, as much business friendly as possible.
Thanks, Vikram. And with that, I think it's a great time to bring Georgina into the conversation. George, you have advised extensively on GDPR since 2016. And in India now, we see a GDPR-based law being proposed, but then junked. And after a couple of tries to make it work, it is then replaced with a simpler Singapore-inspired draft. Is this surprising to you?
No, not particularly surprising. As Vikram has said, the GDPR is a really very lengthy regulation with a lot of obligations, most of them quite significant, that impose significant burdens on businesses of all sizes, from the very, very large to the very, very small, irrespective of kind of materiality, how much personal data is actually being processed, the nature of that data, etc. So the GDPR, we know, sets a kind of really high, really very high gold standard. So to hear that India is proposing something that is not quite so extensive and perhaps more business friendly is not that surprising. And what we're seeing in the UK as well is, obviously post Brexit, we have some more freedom to look again at our regime in the UK and think, well, is this fit for purpose? Can we make any changes to it? And that is what the UK government is looking at now. So we've got a proposed piece of legislation called the Data Protection and Digital Information Bill in the UK, which proposes to remove some of what the UK government thinks are the more administrative aspects of the GDPR. So they're looking, are there any bits of this that we can actually tone down to make perhaps more business friendly? The challenge we have in the UK is that the UK has been deemed adequate already. And so the changes, it needs to be quite careful in the changes it makes to maintain that adequacy. So it seems we too are looking at what bits we can take out of the GDPR potentially.
So do you think there's a trend at work here globally? Like, do you think privacy regulation is no longer just about data privacy?
Well, I'm not sure we can go as far as saying it's a global trend, because clearly when the GDPR came into effect, there was then a definite global trend in terms of lots of countries around the world legislating for something that looked a lot like the GDPR. So we saw that pop up in all sorts of different countries. So there was definitely that trend. Now, maybe there's a trend in actually saying, well, perhaps that's gone a bit too far, and looking at which bits are more workable or not. Outside of the pure privacy sphere, I would say from a UK and an EU perspective, there's definitely looking at, well, do we need to legislate beyond pure privacy, so data that isn't necessarily privacy? Do we need to look at how we can encourage better sharing of that, better access to data more generally? And that's definitely something that the UK and the EU are looking at, to what extent we need to regulate for that. Yeah.
Thanks, George. That's very helpful. Now, let me bring Bibhav into the conversation, who brings in a much needed industry perspective into this discussion. Bibhav, you lead on data privacy for one of India's and most venerable FMCG companies. You're the person who will deal with the sharp end of the stick, so to speak. What are your thoughts, and what are the real pain points that you're seeing?
Absolutely. Thanks, Pratik. I think my fellow panelists, it's good to hear that they align on and they welcome the bill because that's what we believe as an organization as well as an individual. Just to put something into perspective, one of the things is that we've been attempting to achieve perfection with the bill. And that's what we've struggled over the past since 2017. We want everything included. And I firmly believe that specificities in the bill will be detrimental to the industry as well as the public at large because of the simple reason that technology, the evolution of technology, and the pace at which it's evolving, law cannot fathom or is not able to catch up. So having specificities is definitely detrimental. What is important is to have principles, accountability, governance around data, and which this bill definitely does. There are mixed feelings about the bill. Some people would want certain more explanation, but as Vikram said, and I too believe that there are gaps which needs to be addressed. It's not a very pure perfect bill, but I would want to have a law in place which has been under discussion since the Puttaswamy judgment since 2017. We've been prepping for it. We've been telling our businesses that it's going to come. Let's invest further, but the bill has been pushed every coming year. So rather than waiting for a perfect bill, and I can guarantee you that no stakeholder or there won't be a consensus on the bill being perfect. So coming with a starting point, and then as Vikram had mentioned in the start, we have a law in place currently also. While it is for sensitive personal data, it has provisions around privacy, personal data in general. But one of the biggest problems with that was enforcement was lacking. There was no regulator. So we've never experienced it. And for an Indian context also, what we also have to understand is that European countries, including UK, had data protection legislations in the 1980s. They may not have had the kind of enforcement that and rigor in enforcement that the GDPR brings, but they've learned they had a legislation in place which was being enforced to a certain extent. India is still at a very nascent stage. Uh, in getting a heavy regulation of GDPR sort would have definitely been detrimental across all stakeholder. And therefore, I believe that the simplification of the bill is a really welcome step. Uh, we are hoping that there will be more consultations, whether with privacy activists, industry, or experts like you, where they can come with and evolve the law as they learn. Because one of the learnings that we've had as an organization, and then just for everyone, we've been on this privacy journey since the last 3 years, since the Puttaswamy judgment came about. We've implemented controls, governance around PDP 2019 bill because our senior management had agreed that to ensure minimal disruption when the law comes in, let's start implementing things that the government is already thinking about. So we already a couple of steps ahead. And when we went in that journey, we realized the complexities. It's not the legal complexities, it's the compliance complexities arising out of the technology infrastructure processes, the width of the expanse of the operation. And that's where we realized that having specificities is always detrimental to the operation of the industry. Having said that, as I said, it's a welcome step. One of the biggest change that we were rejoicing over was the exclusion of non-personal data. While Europe is also getting into voluntary sharing of data, etc., it's a good practice, but I think it's too early. Burdening the industry with non-personal data compliances when we are still struggling for 5 years to get a law in place on privacy is too onerous and unreasonable. I would believe to put it bluntly. Now, coming to the specific, I won't delve too much on the pain points, but a couple of things that I want to highlight. First is I think the JPC had recommended a clear 24-month period called out the way GDPR had included it. We would prefer that rather than keeping it as a very generic statement that PDP 2019 bill had. It gives businesses clarity that there will not be provisions which on someone's whim and fancy will get notified because there is a clear two-year period. That should be, I think, adopted by the by MITI. The other couple of them I would want to highlight is that while they've introduced deemed consent as a provision, they've still, and then it has been inspired by the Singapore concept of deemed consent, they've not adopted it completely. They've excluded contractual performance, which is a very good lawful basis to process data. I think that needs to be incorporated. The other thing that I think this is not, I wouldn't take credit for this point. In one of the industry forums, this point was raised is that they've included grounds such as vital interest processing, reasonable purposes, etc. Also as part of deemed consent. The problem that arises is that if it's considered deemed consent, can someone withdraw consent? I think it should be categorized as separate grounds for processing of data, not as deemed consent, is what the government should look at. The other is people are rejoicing on cross-border transfer being eased out. One of the things people are missing out on is that while hard localization or mirroring requirement for sensitive personal data and critical personal data has been removed, one thing that they've missed out, and that is one of the biggest concern for a pan global operation organization like ours, is exclusion of SCCs, BCRs, and intergroup schemes to transfer data. Because one of the things that we have to realize is that these notified countries will be far and few. It will depend on reciprocity, political friendship, or other things. And our industry would not be able to just include a XYZ country into the thing. So therefore, to ensure ease of operations, I think these are the three main points. There are, I think, few more that we can discuss a little later. But I think these are a couple of these things that I do see a gap in and has to be addressed in the bill rather, or the act, rather than the rules later on.
Thanks, Bibhav. That's very helpful. Can we now speak a little about the unintended consequences? So, for instance, will this affect the way in which companies, especially smaller companies, now look to enter into and work in India? Bibhav, this is for you.
Sure, I think it will. I think there is it's going to be a conversation now with businesses. While the larger ones will have processes, money, and investment to make, but I think the law currently, as Vikram pointed out, it's simplified. I think it will be a journey. I think we'll have to traverse that entire journey that a lot of other countries have already been doing for numerous years. But I think it will be for smaller organizations also. They may not have to have automated infrastructure, etc., processes, standardized processes, etc. But at least every time you're dealing with personal data, there needs to be a conversation around whether the data is required, where are we storing it, infra security, storage, etc. Maybe larger organizations will do it differently, but I would expect as an individual also whose data is being collected, I'm giving data to startups, I'm giving it to Unilever. I would expect the same protection for my privacy, whether it is a 1,000 crore company or a 10 crore company, because you are holding, I will have to hold the organization responsible. And at least I would believe that consciously, and that's the reason that we need to give time for the industry and data principles to evolve, understand their rights. And over a period of time, industries will, and I think it'll strengthen, processes will get strengthened. But I think it is the need of the hour. Organizations will have to first think about the data protection, and the need of that data before trying to collect the data from data principles.
Thanks, Bibhav. Vikram, let me ask you the same question. As a privacy lawyer, what do you see the main pain points and unintended consequences which your clients will face?
Thanks, Pratik. And I agree with Vivam completely. There are a couple of things that will keep organizations up at night. I think data localization will be definitely one of them. Let me come to maybe cross-border data transfer at the end of my answer. But there are a few ambiguities, as happens with every particular law, and maybe these ambiguities will go away once this draft bill goes through one series of comments, once it's looked at by a lawyer with all these benefit of all these comments. Yeah, and they can fix the gaps. And there are ambiguities. For instance, certain benefits that are given to data fiduciaries should also be extended to data processors. For example, and there will be some operational issues, like while processing a children's data, to what standard do you treat it differently than from a normal person's data, and what technical measures do you have to have in place to ensure data security? These are all concepts which are introduced in the bill, but these are not currently fructified. I do take Vivav's point that this will take some time. I think what's going to happen is that the data protection board will be constituted. That might take 6 months to a year. When the board comes into existence, then this will gather pace, because then the board will start rolling out regulations around children's data, regulations around security standards, and similar. I think then organizations will be better placed to figure out, okay, fine, how do I need to change my IT systems to ensure that I am abiding by the so-called reasonable security standards which are set forward by the Data Protection Board. I think a connected point is that this is the high impact, high stakes law. It is a high impact, high stakes law because a data breach nowadays has multiple consequences. Forget about the business and reputational consequences. A data breach triggers various liabilities. Earlier this year, India also notified new directions for cybersecurity. And cybersecurity, the Indian cybersecurity team has now to be notified within 6 hours of various cybersecurity risks, including data breaches. So no matter what the size of a data breach is, you can have a single data record that has been breached. You still need to go ahead and notify the Indian regulator of a cybersecurity incident. So similarly, I think it's also a matter of considering what the consequence of non-compliance in this particular act are, and they are fairly significant, at least on paper. Uh, as has been reported, and you would have read that non-compliances that are significant can lead to penalties from 50 crores to 250 crores, and this is almost 15 billions US, which is not a small amount by any means. And this can be for even a fairly commonplace non-compliance, like a failure to report, a failure to prevent a data breach, or a lapse in notifying a breach might also lead to a penalty of 15 million, theoretically, admittedly. In aggregate, for multiple non-compliances, this penalty can be double that. The regulator can fine you up to 60 million US dollars for repeated breaches. Maybe when George comes in, she can also touch upon the fines under GDPR, to the extent they have been used in compliance in Europe. But I think the reality is that in India, given the relative size of organizations, it's not inconceivable that tomorrow you might see an Indian unicorn or an Indian startup going under because of a data privacy fine, or even the threat of a fine proving so detrimental to a business that nobody wants to get into it. For instance, would you now start a children focused business knowing that you can be charged up to 500 crores for data breaches? It's like something out of Silicon Valley that you might not know, and you keep incurring liabilities, and you keep accumulating fines for breaches. So I think that needs to be looked at a little bit, and I think this is the proof will also be in enforcement. To what extent is something like this enforced? You know, and maybe George can also speak on this. Is that will this be used to essentially catch the obvious big guys, who are in the crosshairs of data regulation, or will this essentially be a regime in which even a mom and pop shop who are collecting financial data, they are treated as on the same level as a global operation? Will it be something like that? We hope not, but that proof is in the enforcement that we will not know until a few years down the line. And let me then maybe address the point about data localization that Bibhav brought up, and I think that's also one of the highlights of this bill about data localization. I think a number of people who are on the webinar, a number of Indian businesses deal extensively in data, personal data, but not personal data of Indian individuals. This is data of, let's say, European or US individuals. This is data that is brought into India for processing. You can be an IT service provider, you can be a CAS provider, a platform provider, a SaaS provider, and you're essentially being given a lot of data of various individuals, but that's technically not data that is subject to Indian regulation. On the flip side, you also need to receive that data through an adequacy assessment, or through some sort of other mechanism. Now, the one-way flow from India to abroad, like Bibhav touched upon, seems to be subject to the government's requirements. Now, the government will essentially whitelist countries. It's not so much having a blacklist that, okay, fine, don't transfer to A, B, and C, very obvious ones, but you can only transfer this data to X, Y, and Z. Japan, South Korea, the UK, the EU, the US being the obvious culprits. Now, there are various concerns around this. Like what happens on day zero is on day zero. transfer of data from India to abroad completely barred, or can that continue? What is the process for adequacy? Will adequacy will then be caught up in a bilateral negotiation? Will it take much longer for India to recognize the US, given the state of privacy regime in the US, than it would the EU? If the India, on day one gives adequacy to both the EU and the US, some lawyers will ask on what basis? Those are very different jurisdictions. So all this needs to be worked out, and I think, uh, like Bibhav, let me end by saying that all this cannot be by government diktat. I think there has to be a little bit of flexibility given to organizations to deal with data. Of course, given some basic standards. One exception that we have not seen in this bill is an exception for processing data within your own group company. A lot of data of Indian employees of multinationals is processed abroad, just because of good reasons, because there might be a group wide insurance policy, because there might be a group wide benefits policy. So transferring data of Indian employees abroad, a foreign service provider providing service to Indian customers and the other way around, this all should be allowed, subject to, like we have said, contracts, subject to SEC, subject to binding corporate rules, and not merely depend on government diktat, because that like I'm sure George will tell you, doesn't work quite perfectly, even in the case of the EU.
Thanks, Vikram. Let me bring George in here. Vikram referenced cross-border data transfers in his response just now. The current scheme of naming countries as safe harbors for data transfer is obviously modeled on the GDPR. What was your experience of international data transfer system while advising on GDPR, and how do you see this working out in practice?
Yeah, thanks. I'll talk about cross-border transfers, but I did also want to pick up on a couple of Vikram's other points around enforcement things. But on cross-border transfers specifically, that is an area where there has been so much development over the last. It's quite a turbulent area under the GDPR. Many of you will have heard of the dramas around the Privacy Shield, prior to that, safe harbour, etc. So it's one of the more difficult areas under the GDPR. But as you, Vikram, Bibhav has mentioned, there are various ways of transferring data outside of the EU and the UK. Adequacy decisions by the relevant government or the European Commission being one of them. So that is one way. And there is, as you say, a white list. The EU has a white list. The UK has a white list at the moment. Those are identical, I think. But those adequacy decisions take a long time in our experience. So between 1 and 2 years for DCMS in the UK or the European Commission to deem another country adequate, and it's a very long process. So those, for example, there was recently the UK has deemed Korea adequate, but that took quite a long time, and the European Commission before that took a couple of years to deem Korea adequate. So that's adequacy is great, and it then means that when transferring data to an adequate jurisdiction, the business doesn't need to do anything else. It's specifically in relation to the transfer. So that is the ideal state. That's great. But where there aren't adequacy decisions, and there aren't in relation to some very key business jurisdictions like the US, like India, then the version of it have other ways that you can do it, and those are critical because many of our clients will rely on those other ways, and those are binding corporate rules, which are usually used in an intra-group arrangement. So that generally allows transfers intra-group, either controller to controller or controller processor basis, and those, once they are in place, are very helpful, but in our experience, they're very time consuming and they're very expensive. And so actually, it's generally the much larger organisations that have the time and resource to put BCRs, binding corporate rules, BCRs in place. The most common way of transferring data where there isn't an adequacy are the standard contractual clauses. And those are a set of clauses with various modules within them that you put between you, the exporter in the UK or the EU, and the importer to effectively give a level of protection to data being transferred that is essentially equivalent to the EU GDPR and the UK GDPR. And that, in our experience, is that where there isn't an adequacy decision, that is the most common way of transferring data. And yes, it's a piece of paper, in a contract. But as well as doing that, there has to be this risk assessment where you look at actually in practice what is the level of protection when you're transferring that data. So you've got standard contractual clauses accompanied by a transfer risk assessment, accompanied potentially by what's called supplementary measures. And those three things together provide a package of protection around data. And so what I'm understanding from Vikram is that actually the Indian law doesn't have that mechanism at the moment, and that in our experience has been for a long time and will continue to be a really essential part of allowing international flows of personal data from the EU and the UK to other jurisdictions. So it would seem problematic if that mechanism wasn't there. I don't know whether you want to carry on cross-border transfers or if I should pick up on enforcement or do that a bit later. What do you? Enforcement. I think I just wanted to pick up because Vikram mentioned enforcement and the levels of fines under the proposed bill. And as most people on the call will know, there are also very high levels of fine under the GDPR, which are either a fixed amount, 20 million euros or 10 million euros, or a percentage of turnover. So it's 4% of worldwide turnover at the max, which obviously can be quite significant. So we've had the GDPR now in effect for 4 years, and in that time we've definitely seen increasing more and more fines as I think regulators kind of get through their pile of complaints and investigations, and we have seen quite a few very, very big fines, but those, as Vikram hinted at, have been largely against the very, very big household names, so social media platforms, technology companies. They're kind of going in at the biggest, and I think the logic behind that is, well, that will then set a precedent which will kind of trickle down, and perhaps other businesses will look at that and think, okay, now I'm going to adjust my practices. But that's not exclusively the case. So when you look at actually individual regulators, and in the EU each member state has a regulator. Germany has 16 regulators. So if you look at actually each individual one, their fining practices, you'll see that there are quite a lot of fines issued actually that are much smaller than that for, say, not responding to subject access requests fast enough. So yes, you get the big headline fines, but if you actually look at the detail, there are quite a lot of fines that are much lower than that. Separate from the fines, some regulators, and the ICO in the UK in particular, has always said that the fine is a last resort. So our regulators have a whole suite of powers, including fines, but things like reprimands, warning, orders to stop processing. And those are all other things that regulators can do aside from fining. And the ICO in the UK is particularly keen on those other enforcement powers, potentially as a kind of precursor to fining. So it will say, well, I'm going to issue a reprimand, and if you don't comply with that within 3 to 6 months, then you'll get a fine. But that's what we see. So it's a full range. Yes, the big fines, but also some smaller ones, and also quite a lot of exercise of other powers outside of the fines. I'll stop talking.
No, thanks, George. That was extremely helpful. Let me just try bringing Bibhav back in and moving a little on to the brass tacks here. So, Bibhav, what are the next steps for an in-house privacy controller? Do you think, are there any best practices or contingency plans that you can share, or how do you approach a task like this?
Absolutely. I think I'll break down our journey and what we've learned over the last 3 years while trying to implement the PDP 2019 in the form it was. The first thing that we realized is that I think getting a whole stock taking and understanding the technology infrastructure operations for organization was the most difficult part of it. As lawyers, as compliance managers, governance specialists, etc. So one of the things that we realized is the first step would be to acknowledge that there is a need for a team. I think resourcing is very important because there are multiple teams with different responsibilities. Privacy, data ethics, governance may not be at the priority. So having a lawyer dedicated to privacy, having a governance specialist, because one of the things that we have to be conscious of is as lawyers, we understand the technology the law, we can interpret it to a certain extent, but when it comes to practical implementation and applying it in the context of technology, we've struggled. I think it took a lot of time for me, my colleagues, to upskill themselves to understand technology to the extent of being able to advise, even on the PDP 2019 bill. So having a team, and it needs to be a mix. I think you may take team members from your information security, but having a dedicated people accountable for this compliance, a squad of such sort would be important. Upskilling them is one of the first steps. Second step would be stock taking, as I said, understanding the entire operations, what kind of data you collect, the gaps that are there. I think that is still a journey for us, and then I think it will be, and then we are hoping that we've come close to completion, but in the last 3 years we've learned a lot. So it took 3 years to understand where all our data resides, what kind of processing, because it's far and wide. There are brand managers maybe, or salespeople running campaigns, etc., where data would be collected of customers, consumers, etc. So getting a hold of that was important. One of the things that we also realized that there is no gatekeeping mechanism that is possible. If you have a gatekeeping mechanism that every data processing activity goes through some squad or a privacy office, this thing, it is inefficient for the business at the pace at which digital processes work. So therefore, you'll need to definitely allow them to operate, but at the same time, understand the processes and the operation, the digital processing operations in a manner to bring standardized governance around it. Now, those are the two things. The third thing that came about is upskilling. Apart from the squad upskilling, is upskilling your employees across. And we've, over the last 3 years, been having awareness sessions for our IT colleagues, our HR people, our marketeers, etc., just trying to drill down that there is a law coming into place. These are the finer principles. We don't need to get into the nuances of obligations, but at least to tell them that if you're processing personal data, please consider these basic principles, seek legal advice, or talk to your data governance lead, etc. So these three have been, I think, the fundamentals of preparing the organization for the new law. Once that is done, I think I think we are still learning, and we need, as Vikram mentioned, Georgina mentioned, there are the nuances in the bill that will come about, which will get plug those gaps. But be it DSARs, we've tried implementing DSRs before the law is in place, and we've realized that getting hold of where the data resides itself is a task. Responding in 30 days is not a menial task, whether under GDPR or in India. So I think those are things that we'll have to learn after stock taking. And I think these three, if we start with these three over a period of time, I think if we get the 2-year period, we will be able to, organizations will be able to get a hold of it. But having accountability beyond compliance legal is very important for this bill to really, the compliance to really land for the organization. So just to give an example, like we now have a chief data officer who's responsible for data governance and privacy along with me, so that she brings the technical aspects, the accountability on the IT infrastructure, IT people, team functions. And therefore, those are the things I think may help an organization to prepare for the new law that we are going to see in 2023.
Thanks, Bibhav. That's very helpful. Let me bring Georgina in right now, and could you just tell us how to prepare for the new law based on your experience with GDPR?
Yes. So I'd agree with everything Biphav said, absolutely everything. The upskilling is really essential. Taking it outside of legal and compliance, couldn't agree more. All of that. The other thing, I guess, and it sounds obvious, and I think it's probably similar with any compliance project, and Vikram has referred to the importance of the potential 2-year grace period, but this stuff takes a really long time in our experience. And back in 2018, we had a lot of businesses who'd left it far too late, really, and were coming to us in kind of March 2018. They had 2 months left before it came into effect, and it was nowhere near enough time. So take more time than you think, start preparing. I think throughout the process, our experience was that it's important to prioritize. So it is going to be incredibly, particularly for the GDPR, which is obviously very extensive and quite granular and specific, very difficult to necessarily comply 100% with all aspects of it. And so there is a constant question of, well, what's the priority here? What are the priority? What are the highest risk areas? Obviously, not only to address those, but to acknowledge that those will take the most amount of time to work through. So that kind of constant prioritising, bucketing into areas of risk and filtering the kind of project management through that way was really important. The other thing we've seen, not necessarily in the run-up to GDPR coming into effect, but since, is that there are quite a lot of technology tools that our clients use to help with mapping their data, for example, or doing impact assessments, or there's kind of a whole cottage industry of tools that have come up to allow clients to do that, and they're not perfect in any way. And I would say this, but they definitely don't replace the lawyers. But they are a really useful tool, particularly as Bibhav said, that the legal and compliance team can't possibly do everything, and so we need to kind of allow the business to continue operating, and those tools definitely help with that.
Thanks, George. Vikram, let me get back to you. And like we started, the same question. What do you think happens next?
Thanks, Prateek, and great lively discussion. Once again, of the same mind as what George and Bibhav said about how to go about all this. It's all about planning. It's about starting with a checklist and figuring out what data do you have in your organization. I think that's the question that most of us actually need to answer, and most of us actually don't know about. And there are surprises every time you go to various gatekeepers and departments with the list in your hand and ask them what do they do with data. That's something that you can get started with as soon as possible, because even though we're a few months away from the bill becoming law, this, like Bibhav said, takes time. It's not something that you can turn on a dime that easily. Just to close out, and I'm aware that we'll try and take a few questions. So just to close out fairly quickly, I think the draft privacy bill has been out for comments for almost a month. It's out for comments until Friday. I think it will be revised post that. We don't know as of yet whether there will be one more chance to give comments, and we encourage everybody to give comments, on the bill right now. The bill, like I said, will be taken up next year in the budget session. This will probably be in February or March of 23. This will be passed. And I think, then to Bibhav's point, it remains to be seen what is the grace period or bedding in period given for businesses to get their heads around compliances. Some compliances might become applicable on day one. Some compliances might actually need a data protection board to, come in and actually legislate. So that's broadly where we are. The bill is a few months away, and full enforcement is a little bit further away. But I think using this time usefully to start on your journey to the data privacy compliance is the right thing to do.
Thanks, Vikram, and thanks everyone. We still have a few more minutes, so in case there are any questions, please let us know. And you can drop down it in the Q&A section or the chat section. In the meanwhile, I'll read out a couple of questions which we had received while in the registration forms. So yeah, anyone, please feel free to pick this up. So one of the questions says, what would be an optimal policy to adopt for an organization that has its headquarters outside India with primary operation in India? Vikram, George, anyone?
Yeah.
Yeah, Vikram?
Yeah, let me take it up. I think if you are dealing in the data of Indian data subjects, you will be required to comply with the law in pretty much all its forms. I think one thing that we're still sort of giving comments on and figuring out is that will it actually require you to have something on soil? Ideally not. Ideally, from a business continuity, from a business ease perspective, we should be able to offer services in India, without on the soil requirements and compliances. But I think there will be some compromise required on that score. The Indian regulator will be conscious that being outside of India puts you out of the reach of Indian law, Indian courts and other enforcement body. So I think there will be some need for having a representative in India on soil, or having some sort of other mechanism based on which an Indian data subject can actually reach you. They can reach you, they can put their grievances in front of you, and you can be required to essentially make sure that their voice is heard. So I think to a large extent, because it does away with hard localization, this bill gives a benefit to foreign service providers, but at the same time, we do expect a few compliance requirements, particularly around the two aspects of customer grievance redressal. And I think, as usual, there will be a government surveillance, short circuit that the government will want you to honor.
Thanks, Vikram. Another question has just come in from Richa Bhagat. Is data of foreign individuals collected in India also governed by the bill?
And I think that that's also one of the areas in which there is a little bit of ambiguity in the bill, and we'll be giving a comment on that basis. Now, to my mind, if an individual foreign individual's data is collected in India, that should be subject to the same protections. For the simple reason that this is essentially a matter of territoriality. If a foreign individual comes to India, stays in a hotel, and that hotel has his personal data, that personal data should be treated on the same basis, on the same level of protection as others' data. And to my mind, not treating foreigners' data in India with such certain amount of protection will lead to an issue with adequacy. So if you're saying that if a foreigner's data is either collected in India, or it is in some way processed in India, but it has no protection under law, that will be a little bit problematic, even when you're going to somebody for adjudicating adequacy. I think to bear in mind that the Puttaswamy judgment, the Indian Supreme Court's ruling applies to all persons. It's not a citizen-specific ruling. So the right to privacy in India, as far as the fundamental right is concerned, is a right given to all individuals, regardless of their citizenship. So theoretically, and this needs to be clarified, subject to comments, uh, the data of a foreign individual should have the same level of protection.
Okay, thanks, Vikram. There's one more question on what do you think is the impact of the new bill on one hand, on entities such as stock exchanges, and on the other hand, the impact on individuals? Uh, Anyone? Bibhav, Vikram?
Sorry, Pratik, can you repeat the question? I heard part of it. My network was a little. I'll just switch off the incoming video for a while. Sorry, if you can repeat the question.
Sure. Sure. So, what do you think would be the impact of the new draft bill on the one hand, on entities such as stock exchanges, and on the other hand, the impact on individuals?
Okay. I wouldn't be an expert on the business operations that a stock exchange has, but the limited knowledge I have, I wouldn't treat it any differently than any other organization. I think this simplified law has certain principles, and you will have to comply with those, whether you are either processing databases deemed consent because there's a legal requirement under SEBI regulations and so on and so forth, or you're collecting data even as KYC, etc. I think all those obligations, whether you're a stock exchange, a consumer products company, or health service provider, would be the same. When it comes to individuals, I think while this bill has introduced certain obligations on individuals to ensure there are certain obligations which didn't exist for data principles, but overall I would say that there's not much from a data principle perspective in terms of obligations and compliances. I think what will happen with this bill and the conversation that it starts is awareness amongst individuals or the public at large, which will in turn increase obligations for the data fiduciaries or data controllers in general, because there will be data access requests, there would be queries, grievances that would be raised. So I think there will be minimal obligations, at least from an individual perspective. But unless you're stating that individuals as data fiduciary, then domestic and household purposes have been exempted. But as a business, if you are, then it depends on the kind of whether it's digital processing. I think they have done away with this entire manual processing, while the privacy activists would not agree. I think the logic that the government is taking is the maximum harm that can arise out of any processing is when the data is in digital and data is possible. A register or attendance register being misplaced may not result in such kind of harm, etc. Is what they believe, and they've restricted the scope to digital. Because of that, I think individuals, depending on the kind of processing they are doing, they will be obligated under the bill. Maybe the kind of processing, etc., will determine the kind of level of compliance and the scrutiny by the regulator. But I don't see any difference if an individual is a business processing personal data digitally of any data principal in India. Will have the same kind of compliance, unless it's a SDF, as Vikram had elaborated on.
Thanks, Bibhav. There's one more question. Are there any licenses required, to process personal data for Indian nationals and biometrics in India? Vikram, do you want to take it?
Sure. Just and I'm aware of the time, so just very quickly, there's no license that the Act contemplates. There is a certain level of additional treatment that will be given to special significant data fiduciaries. So I think this will be depending on the volume of data that someone's holding. So if someone is holding large amounts of biometrics of Indian individuals, this may be in the course of providing smart cards or other solutions, to the Indian government, for example. In that case, you might become a significant data fiduciary. The parameters are yet to be defined. I think there will be no license required, but there will be certain compliances required. There might be a requirement to notify the authority if you are qualifying as a significant data fiduciary, and there will be there could be, to my mind, a requirement to get an audit done on your IT systems every year and submit a report. And this will basically be with respect to absolutely critical data fiduciaries. For a person, if someone is holding biometrics of a million Indian citizens, they might be designated as a data fiduciary of significance.
Thanks, Vikram. I'll end with George with one last question, a broad question, more from a global EU UK angle. Uh, Keeping today's discussion in mind, where do you see global privacy regulations going?
Wow, what a question to end on, Pratik. I don't think, clearly global privacy regulations are not going anywhere. There will always be privacy regulation, and there will be, I'm sure there will be more of it in countries that don't have any. So we're going to see, it won't be going anywhere. I expect that perhaps we'll see a move away from the gold standard in jurisdictions which deem that that isn't practical, or is, as you say, too big a leap from where they are now, or perhaps in the UK perspective, actually we're there, but we would need something more business friendly. So I think perhaps there will be move away from that gold standard. But more generally, I think we should be also outside of the personal data sphere looking at data regulation more broadly, and that is an area that's particularly being looked at within the EU and the UK now that we've kind of got our privacy regulation. We're looking at, well, to what extent do we need data regulation more broadly? So hopefully that's a quick fire answer to your very broad question, Pratik.
Thanks, George. I think Bibhav has something to say on this.
No, Pratik, just one closing remark I just wanted to make, because one point I missed out. One of the major things as an industry, at least an experience of enforcement regime in India, one of the most important things, at least I believe, is required in this current context of privacy regulation is a regulator which understands and appreciates the practicalities of the technology environment. I think whether it is in terms of evaluating the level of valid consent, the security safeguards, and therefore the composition of the data protection board, the inclusion of experts, technical experts, judicial experts, etc., would be very important. And I think they'll have to come from, unlike the general enforcement regulators that we have in countries for maybe food laws or any other Factories Act, etc. The regulator here will have to think differently, would need to be very progressive, because the kind of environment that they're regulating or is something very different. It's a completely different animal when compared to operating a factory, etc. So therefore, that would be, I think, a very important point from an industry perspective that I wanted to lay it out for everyone.
All right, thanks, Bibhav. And I think with that, we have come to end for today's roundtable, and I hope everyone enjoyed it and found it informative. Many thanks to all the speakers, Bibhav, George, Vikram. Thanks for joining in and providing so much useful information for all of us. And thank you for everyone joining in. And if there's any questions, please feel free to drop in an email, and we'll get back to you with the recording later this week. Thanks again. Bye.
Thank you, Prateek.
Thank you.
Thanks everyone.
Thank
Bye bye,
you.
Vikram. Bye, Georgina.
Bye.